at the later time? What do you think? It's like a common law decision, of course. A decision in a particular case involving other parties, but you have a claim of equality to be treated just like them. Not a conclusive claim, but a prima facie claim. Is that an interpretation? Is there a text? What's the text? There's a past decision, right? There is a decision. There's something he did. What generates the moral claim of equal treatment is that he treated his son in a certain way. If you look at the way that Anglo-American precedent creates its common law, it does the same thing. It says, could there be a text? Sure. That's why judges write opinions. But subsequent judges don't regard those as texts. They regard those as the deciding judge's provisional theory of what it is their case stands for. But what the precedent case actually stands for depends on the subsequent judge's generalizing powers, not on the deciding judges. That's why in the practice of what's called horizontal precedent between courts of equal dignity, the opinions of the prior judges are only theories by those judges as to what the case stands for, and subsequent judges feel completely free to narrow, to broaden, and in any event to restate what those past decisions represented. They do that in part because equality is not a formal value. Treating people equally is not to treat them equally under a stated category. It is to treat them equally when they are equal in all morally relevant respects. It's not a formal value, it is a substantive moral value. In which event, the good of precedent dictates that you do not treat the past decisions as a text. You treat them as decisions that have to be respected because equality plus the rule of law values demands that you do. But it does not demand that you treat the judge's statements at the time they make the decision as itself a text. Indeed, it cuts against it. And if you look at the way the precedent is practiced in common law countries, you penetrate the stated rationale to discern the actual rationale, because that's the only thing that binds you as a subsequent judge. In which event, Bentham's right. Common law reasoning is moral reasoning done in the special case where you have to pay attention to non-ideal history that went before because of equality and rule of law value concerns. But nonetheless, it's to take those concerns into account and then do the best moral job you can with them. It's not in a useful sense interpreted because there is not a text, valid interpretation of which gives you new reasons for action. This is just Lord Nelson going straight at it. What is the right answer as to whether this daughter gets to go to the rock concert simply depends on substantively what's the risk versus the benefit and what's the demand of equality from how past cases were treated. Not what was said then, what was done then. If you practice precedent that way, it turns out not to be interpreted common law reasoning, because there's not a text and there's not a reason to treat what could be a text, judicial opinions, as a text. What you do is in fact generalize rather than interpret. That's not interpretation by my lights. Now the third thing about law practice is this mysterious thing called constitutional law, which in America is terrific. What would you say the text for American Constitution? I actually don't know the Brazilian tradition. I find ours amusing. I don't know if yours is funny too. I've taught constitutional law for almost 50 years. I'm still amused by it. What's the text of the American Constitution, would you say? Everybody usually points to that parchment, that thing that's 6 articles and 26 amendments, short little thing. Even that's not completely agreed upon. Akil Amar at Yale has an article. It's not what got him 10 years as a Yale law professor, because nobody should do this stuff. He went through all the different parchment versions. The punctuation is actually different. So there actually isn't an authoritative parchment. There's different punctuations between the different parchments. Anyway, that's certainly, of course, the first thing people mention, is that written document. Of course, some systems have constitutions, but they don't have written constitutions. What's the text for them? Is the text some set of understandings that people have, or some particular people, like Herbert Hart's judges who have an understanding about the secondary rules of recognition. Is the text what the highest court has said? Charles Evan Hughes used to say, the Constitution of the United States is what the Supreme Court says it is. When you teach constitutional law in America, you actually hardly ever read the damn document. You almost always are teaching Supreme Court opinions. Is that the real text? Is the text what Hamilton and Madison thought in the Federalist Papers, the people who wrote a lot of the Constitution? Is it what they meant, not so much what they said in the document? Is the text what the original audience understood them to mean in the ratification conventions of the 3/4 of the 13 colonies? So the text to it question's interesting to start with. Well, what exactly is the text? It's not a descriptive question, it really is an normative question. What do you have reason to treat as a text in American constitutional law? What should you regard as being beyond doubt, something you have to pay attention to if you're doing American constitutional law as a judge or as a lawyer? Jeremy Waldron and I used to teach this course for jurisprudence for judges, for the state as well as the federal government, up at Lake Tahoe, nice place in the summer. Get a lot of judges to come. We had an hour and a half for each session, and Jeremy, fortunately, was assigned the hour and a half where we were going to talk about exactly this question. What's the authority of what text of the American Constitution? So he raised that question. The Chief Justice of the California Supreme Court at the time, Malcolm Lucas, stood up and said, there's not a person in this room that would question the authority of that document and sat down. Judges are really authoritative. Not a single judge would engage the question. Jeremy and I had an hour 29 to go with ourselves. But you know, that's what you want. What is it that made that judge, Chief Justice Lucas, think that that text is so authoritative that it actually just doesn't even need to be questioned? It does need to be questioned, but nonetheless, what is it that makes it that authoritative? All the stuff we teach kids in American schools, as I said earlier, strikes me as a fairy tale. That our super wise founders, or that they represented us, or that we've consented implicitly by sticking around as if emigration or revolution are costless activities. That in some sense, that this is a democratically enacted thing that can be justified the way authority of statutes can be justified. Not so. What if you think the only justification is de Tocqueville's? The Constitution is authoritative in America because actually it's accepted, which is not to confuse de facto with de jure authority. It's not to say because it's accepted it's authoritative. It's rather to say because it's accepted it can serve a real value in making otherwise irresolvable social disputes into resolvable legal disputes. That's a good that its acceptance makes possible, and then the only question is the social fact, what's really accepted? And if you look in America, the only thing that's really accepted really is the written document. Everything else is up for grabs. So you find in today's American politics, all stripes of the political spectrum paying lip service to them defending the Constitution. And what they mean is indeed that document of 6 articles and 26 amendments. They don't mean framers' understanding, Supreme Court opinions, or all the other things that might realistically be thought to be text for constitutional law. That is a peculiar notion of authority, because as I said, it depends in part on how good you think the interpretations are that that kind of text issues. Thurgood Marshall, the first African-American justice of the U.S. Supreme Court, said, you know, we're my people. And you may remember that text has the Compromise of 1808 in it as well, that made slaves half people until 1808 under the American Constitution. So it's hardly perfectly moral. My response to Marshall always was, yeah, but is it good enough for government work, as they said? Namely, it's not perfect, but given the peace-resolving function that it so usefully serves, it's pretty good, even though not perfect. And thus, on balance, should have our allegiance. If you think that, then we have a text, and some rather limited reason to treat it as a text before we know what it means. What's a valid interpretation of the Constitution? Do we have criteria for validity? Well, this is even more contentious, at least in American constitutional law, than statutory interpretation. And what goes under the name of constitutional interpretation has quite a few flavors. I and Nino Scalia, the late justice, got in a debate at the University of Virginia in 1988 that went something like this. Scalia didn't like originalism really, but it does limit the power of judges, so you should limit the Constitution to the things to which it was intended to apply by those who either framed it or heard it in 1787. Moore. Yeah, but those guys, Madison and Hamilton, were actually all natural lawyers. They were moral realists. They were Lockeans. They believed in natural rights. They thought the Bill of Rights of 1791 did not create but only named rights that all humans possessed and thus antecedently existed prior to the enactment of the Constitution. In which event, if you really care what Madison and Hamilton thought, you must care that they referred to entities whose nature should guide the meaning of those phrases, not what they thought the meaning was at the time that they uttered them. It's like the way people use words in general. They refer to something whose nature they only partially know, and they expect better theories in subsequent generations to reveal more about the nature. In which event, more to Scalia, if you're really an originalist, take the history as you find it. The guys you're talking about were natural lawyers. They believed in natural rights. They thought they were referring to those rights in the half of the Constitution that deals with rights rather than powers. In which event, you should construe the Constitution as they would intend you to. Fill out the nature of liberty, of equality, of free speech, of cruel and unusual punishment. Not with their exemplars, not even with their concepts, but with the best ones you can muster in light of your own theory. It's like a statute that tells you in a custody dispute, you're supposed to give the child in divorcing parents to the parent that will promote the best interest of the child. That's not to go to what the legislature thinks is best. It's for each judge to figure out what indeed the best chance for life will be for that kid with either parent. Best meaning, all things considered, a theory of good. No help for it in such cases. In any event, there are many disputes. It's hardly that either of us carried the day on that day or any other. Many disputes about how to construct a theory of validity for constitutional interpretation. But there's a range of things that are plausible to say. So is American constitutional law interpretive? Yeah, sort of. There's a text with a not terribly persuasive, but somewhat persuasive argument for its authority, for reasons to treat it as a text. And there's a range of plausible to implausible theories of validity for the interpretations of the text. So notice for law practice, interpretive jurisprudence gets kind of a mixed verdict. For statutory reasoning, yes. Common law reasoning, no. Constitutional reasoning, sort of, and maybe, is the way I would come out about law practice. My last question, the fifth on the outline, is legal theory. Is what we're doing right now interpretive in any useful sense? We're doing jurisprudence right now, if you didn't notice. We're not practicing law. We're talking about people who practice law. How they should practice it, how they do practice it. Are we interpreting something? What do you think? When you read the classics in this course, in jurisprudence, maybe Law's Empire, maybe Concept of Law, maybe Kelson's Pure Theory, are you interpreting when you do those things? Were those guys interpreting something? Well, I'll give you Hart's answer. Hell no. I'm not interpreting anything, Hart said. Dworkin wants to say I'm interpreting practices. I'm not interpreting any practices. As I said in the beginning of my book, this is an essay in descriptive sociology. Descriptive. I'm describing a concept of law that applies to wherever you would have a legal system. I'm not interpreting practices. There's not a text for me. Do I really care what Bentham and Austin said about this? Do they have authority over me as a theorist? I'm not interpreting what they said as a text. What I'm doing is describing law, which isn't interpreting it. I'm describing what it takes to have law, a legal system. That's descriptive sociology. It is not interpretation. It's only by virtue of Dworkin forcing all interpretation to be internal that he even gets a scintilla of an argument that jurisprudence is interpretive. Because if external jurisprudence is possible, it doesn't look in any sense interpretive. There's no text that we have reason to treat as a text in other theorists' writings or in the law itself, which is the subject of description, but not the object of interpretation. How about interpretive jurisprudence if you're doing Dworkin's own style of internal jurisprudence? If you're doing what I've done for years, teach American judges how to judge. I'm giving them jurisprudence about Anglo-American law. It's very self-consciously internal jurisprudence. I'm not teaching them law in general. I'm teaching them law in the Anglo-American system. Am I doing interpretation of a practice? Dworkin wants to answer that yes. Wouldn't he be right if what you're doing when you teach jurisprudence is become the advocate at a general level? That is interpretive. My last article in constitutional law was on the right to liberty, why same-sex marriage is indeed a liberty right that the Constitution of America protects. I did regard that as an interpretive activity of the text of the Constitution in its liberty-protected phrases. But that's to become an advocate, just like a lawyer, and to become an advocate is to become a vicarious judge. To give a judge a reason to decide is to become a judge to decide. It's the same enterprise. What if you stand back from that and talk about how judges should judge in general? Is that interpretive? Well, what would be the text? Not what other theorists have written about it. Hart's right about that. I don't care what Hart and Dworkin and everybody else have said. I'm going to figure out for myself how judges should judge. And that's what I do. Is the practice of judges in the Anglo-American system a text? Only if you've got a theory of authority that gives judges a reason, and thus who are those who are recommending to judges, theorists, a reason to treat the way they practice judging as a text their future judging should be an interpretation of. Is there such a reason? Only a limited reason. Jerry Postema says, look, if you regard judges as having a coordinative duty, so it's not enough just to listen to Moore and get the right theory of interpretation, you also have to coordinate with other judges so that your theory is like their theory. If judging is a solution to a coordination game that judges are obligated to follow, then there is a limited good in following the practices of other judging in your own judging. That would turn internal jurisprudence into an interpretive jurisprudence. You'd have a reason for the text of other judges' opinions. Absent that, or at least absent that being very much of a reason, then you're free to do what I by and large do. Ignore how judges actually decide and tell them what would be a good way to decide under the Constitution, the common law, and statutes. So end of the day, is jurisprudence interpretive? Certainly not if it's external. More interesting if it's internal. Sometimes yes, sometimes no. So when you get to the Law's Empire in your course, cast a skeptical eye. Dworkin will give you a different theory of what he thinks interpretation is in terms of creative interpretation versus communicative interpretation. See what you think in terms of the measuring up. Is there a text? Is there a reason to treat it as a text? Are there criteria for validity of interpretations of the text? Force the interpretive jurisprudence to answer that question, and you get, I think, a more determined answer as to whether jurisprudence and law practice is interpretive. Thanks for your attention.
Thank you very much, Professor Moore. I think we have some time for some questions. Let's take some quick questions.
First of all, thank you very much for a very interesting lecture. I have two questions. What's the difference in legal questions between valid interpretations and right interpretations? That's my first question. And the second one is, how can we reconcile the right answer thesis and the reflective equilibrium that you said is important for legal practice?
Say the second one again. How do you reconcile the right answer thesis with what?
With reflective equilibrium.
Oh, okay.
And that's
just as imprudent as a puppy barking to a big dog, I'll try to react to your exposition in two ways. My first objection would be this one. Hart opens his book saying that previous theories are like great exaggerations of some truths about law than cool definitions. In some way, you do the same with the theories of interpretation that you criticize. So you say that you reject both communicative model and metaphysical dualist model because they were in some way reductionists. They have some important insights, but when they try to expand these insights to other practices, interpretive practices, they fail. However, your own model of interpretation, when applied to some allegedly interpretive practice, excludes what could be said to be the core or central cases of interpretation in some context of use of this concept. For example, you exclude ordinary communicative use of language in everyday conversation from your model of interpretation. But leaving aside ordinary communicative use of language, wouldn't your model be considered as reductionist as the previous that you criticized? Moreover, wouldn't this reductionism be the symptom of the same philosophical attitude which Wittgenstein considered as a disease, shared by you and the ones that you criticize, of abstracting from ordinary use of language in the search of the concept of interpretation and using this abstraction to measure our practice, as if our practice of interpretation were to account to the theory and not the other way around? This is my first objection. I have a second one if I have time to.
You can make it short.
Okay, so you argue for a sharp distinction between legal practice and legal theory. And my question goes, how would you say that this sharp distinction, how would you defend this claim in face of Dworkin's exposure of theoretical disagreements in Law's Empire, and from Dworkin's arguments in his comments of Hart's postscript in Justice Robes that legal theories have direct impact in practical cases, such as the case of Mrs. Sorson? These are my objections.
I have two questions also. I will be as quick as I can. The first one is this. When you are talking about internal and external jurisprudence, my question is this: does this distinction really make sense? At least I think that Dworkin is doing something quite different. If we are going to take seriously what Dworkin claims about being internal to the practice, I think that he means that you can't actually have this distinction between external and internal. If this is the case, my question connects to André's question. Does it make sense to try to distinguish between internal and external jurisprudence, or is this in Dworkinian terms a sort of nonsense, a sort of no distinction here? This means that the distinction between internal and external is out of place, and with this also all the structures you make about interpretation. And the second question, also related to this one, interpretation. You present interpretation as a three-step dance. I think here we have at least I think a possible projection in Dworkinian terms would be, well, what Dworkin actually argues for the opposite. You must interpret twice, actually. First, you need to find if something, you must interpret if the concepts that people use, the practice people share, they are interpretive. You must first need to interpret them first, and then see if the best interpretation of the practice presents them as interpretive. That's, I think, the movement he makes in Law's Empire. First, you must realize that law is an interpretive concept, and then you have rival interpretations. You must interpret twice, so to say. You don't have, and I think this is a very important point regarding Dworkin's theory about interpretation and about legal theory, actually, because Durkheim presents legal theory as interpretation, and in his general outlook, this is so because we don't have, with law, a concept that works like water, or like the concept of tiger, concepts that have essence or natures. At least it's plausible to say that for Durkheim, the concept of law works akin to an essentially contest concept, not as a concept that have a nature, an essence. So it doesn't make sense, I think, to find a text and then going to interpret it. So I'd like to hear you to talk about those things. Actually, it was clear. It tried to be as fast as I could.
Professor Vigil, would you like to make your question now or in the second round?
You decide. It's up to you.
That's enough for the first round.
It is. It's going to take a while.
Yeah.
A lot of good questions,
No,
actually.
it's okay. Sorry.
The first I was asked about the distinction between right and valid. I talk about valid interpretations because it does encapsulate the sense in which those are the right or correct interpretations. For a natural lawyer like myself, that it's legally valid will be because it's morally right, all things considered. But I intend it to be something of a synonym when I talk about interpretations being valid. Namely, they're the right ones for persons in this practice to utter. So I don't intend any distinction. Valid conveys the fact that the rightness is affected by the law and that you're within law practice in which event those interpretations are right. It's to emphasize that it might not be the right thing to do if there were no prior statutes or precedents. So valid simply is for me, in that sense, synonymous with legally right for the person making the decision. You asked, secondly, whether the right answer thesis could be reconciled with reflective equilibrium. Look, reflective equilibrium in Rawls's hands, Rawls was both my teacher and Porter's, was an epistemic thesis. It's how you arrive at thesis. It's how you discover, first part, and how you justify moral truths. But it's not a metaphysical thesis about what the truth is. That, at least in Rawls' early days, before he went political rather than metaphysical, that's a metaphysical question. I think even the late Rawls would say, is it just that he didn't think politics should use it? But that's the metaphysical question. The right answer thesis, in Morgan's hands or mine or others, is a metaphysical thesis that there is a mind to independent reality to which the truth of every singular legal proposition will correspond. And even though you can't know it, no demonstrability for it, let's say, it's nonetheless true. It's a metaphysical thesis, not an epistemic thesis. Reflective equilibrium, you might say, is the best you can do to get as close as you can to knowing as much as you can know. But what's out there, the truth conditions for these propositions, will be richer than what you know, presumably, unless you're God. The next question, or really set of questions, was whether I myself am a kind of reductionist, and I think you had me rejecting the communicative model. I don't reject it, I enfold it. I include it as a lesser. It fails as a model if it aims to be the model of interpretation rather than an instance of interpretation. Because look, in ordinary communication, you can answer my three questions quite handily and make sense of the communicative model. It's the right model for ordinary communications. Namely, you want to understand something, I want you to understand something, I form that semantic intentions, use two kinds of conventions, and hopefully if it all works, I cause you to believe what it is I meant you to believe. That's all fine. It is reductionist in the sense that, contingently, this distinctively interpretive enterprise that you're engaging to by listening to me also gives an explanation of why I'm speaking. My intention is not only what you're seeking as the object of your interpretation, it is also the cause of what I'm saying. In which event, the interpretation is an explanation, and in that sense I'm saying it's reductionist. But notice, communication as a form of legitimate interpretation, it's what Freud did with dreams. The reason he separated 6 chapters from 7 is because it turns out for him the best interpretation was also the best explanation of the dream. To find its meaning was to find the repressed wish that caused it. But as Wittgenstein said, that doesn't have to be true. It could well be the best interpretation has nothing to do with the best explanation. The trick is to see that the interpretation, being a good or valid interpretation, doesn't depend on it being necessarily the best explanation. So I'm not reductionist, and neither are the interpretive activities of people who do communication or dream interpretation in the way that I suggested. So to put it another way, I explain why communicative model is good in its limited domain, but it's too parochial to pretend to be a universalist model of interpretation. I think you also had a notion about practice and theory being irreconcilable with Dworkin's use of theoretical disagreement. But notice there's nothing in his use of theoretical disagreement within a practice that's inconsistent with distinguishing the practice from my sense of a theory about the practice. Theoretical disagreement, as Dworkin himself says, doesn't mean that lawyers have to become jurisprudents, although I think he thinks that. It only means that you have to remove yourself from the obvious law and find unobvious law that is itself, in some interesting way, a distillate of past obvious law, and then you fill in what's not obvious now in light of this unobvious law, whether you call it a conception, a principle, or whatever the Dworkinian things are. So that's within the practice. It's a play on the word theoretical to think that in any way impugns a distinction between theory and practice. Dworkin doesn't want to draw that distinction, I do, but that debate I think is untouched by both of us. We can each happily talk about theoretical disagreement, where what we mean is, inside of a legal system and a set of laws, a rich set of standards, there will be some unobvious things, call them principles, that you use to fill in where the obvious stuff seems to run out, or at least seems to lead in the wrong direction. So I think that's only a play on the words that make that look inconsistent. With regard to the second set of questions, third set of questions, you say I can't have a distinction between internal and external, yet Dworkin says that. I didn't hear you do any better than Dworkin on why that's the case. I gave you two readings, one Peter Winch's, which I think is epistemically interesting and metaphysically empty, and the other was Carnap's, which is metaphysically empty but not applicable here, metaphysically significant but not applicable here. I don't know a good reason to think you can't stand outside of a particular legal system to actually ask about it. Maybe your second question is what you think the answer is. Because you, like Dworkin, wanted to say law is an interpretive concept. It thus doesn't have a nature. It doesn't have an essence. The second thing you said was Galley's old notion. It's an essentially contested concept. Ask yourself the question Dworkin never asked. What do you think makes a concept essentially contested or interpretive? Is it conventional? Is it that it's so regarded that is people contest it? Or that people say they're interpreting it? Is it Fishian in that sense? Is it purely conventional? That's what people think they're doing, so therefore that's what they're doing? I don't think it's that dull. I think the idea that something's interpretive is much more interesting as an activity. It's not that concepts come labeled. You can't look at law and say, interpretive concept. You rather have to ask the normative question, is there a point for people practicing either the practice of law or theorizing about law, two different practices? Is there a point to them regarding something as a text, meaningful interpretations of which gives them reasons to believe something or to do something they otherwise didn't have reasons to do? That, I think, is an interesting notion of interpretation. I don't get that by staring at something and trying to divine out of the conventions of its usage whether it's an interpretive concept. If you look at Law's Empire, I think he thinks you can stare at something and say it's an interpretive concept. He's right about some of the examples. Courtesy is an interpretive concept, but not because it's so regarded, but rather because there is a point, giving respect to people, that demands that you interpret the practice so that it's understood by its recipients as respect. That makes sense.
Thank you very much. I'm not a student of Ronaldo's course, and my question is much simpler, and it's not from the point of view of legal theory. Your answers in point 4 Is the practice of law properly regarded as interpreted by statutory law? Yes. Common law? No. Constitutional law?
Sort of maybe, yeah.
Yeah, not, yeah.
Mushy.
So, I'm a constitutional lawyer, so I'm interested in if your answer, your hesitation, or your kind of sort of to the third question is inspired or is limited to the American experience. Because if I think of the Brazilian experience, the constitution is a statute like almost like any other. Just and if you think about constitutional amendments, it's even clearer. So I would say yes to the first. I would say yes, definitely yes to the third, and maybe I'll say yes to the second. But second is kind of, we don't have common law, we have presence. It's not interesting. Would you maybe answer yes to the third question if you think about other questions, other countries?
That's right. No, you're quite right. I was being intentionally parochial. I was talking about American federal constitutional law. And you can easily imagine how it could become a truly interpretive enterprise. I mean, suppose Tom Jefferson had his way. He told his compadres that they should reenact the Constitution every 21 years because every generation should be entitled to its own Constitution. And that would give them authority, that generation, because they adopted it. They chose the representatives who then wrote it and ratified it, in which event they had the democratic input to its content. And then, like a statute, there would be a theory of authority that would make that text authoritative for them. It's a bit like some states. The California state constitution is easily amended, in which event it's very detailed, like the Brazilian constitution. And it's practiced more like a statute because you can easily amend it. It has thus the imprimatur of democratic enactment as its theory of authority. So yeah, you could have constitutional law that looks a lot more interpretive like statutory law. American constitutional law is so interesting because it just isn't.
Okay, Professor. Thank you for your lecture, Professor. My question is, when you say that we have some local contexts that allow us to point something as a meaningful text, and that practice give us local constraints to treat something as a text, it really seems to me a type of argument about Wittgenstein's form of life. My question is there actually an inspiration in this sense? And if the answer is yes, what will be the extension of the form of life, and how it could differ from a communitarian approach of form of life?
Thank you for your lecture. I just wanted to follow on the question of Professor Virgilio. I understood that you would say that yes, it is possible to treat a country's constitution as a text. But then, what I understood from your answer, not explicitly but implicitly, is that you would have to have good reason to do that. So, what I understood is that, yes, if you have a practice of constitutional amendment or reenactment that could grant that practice, or where we could recognize a democratic practice within constitutional practice, then yes, we would have a reason to treat that as a text. Is that correct? So we would have to find a reason to treat that as a text because it imposes lots of constraints in the normative practice in general. Is that correct?
And Michael, if I can jump in Ana Luisa's claim for some clarification on some of the concepts, could you just, for the sake of making some of this concept more clear for the audience, how would you distinguish the idea of form of life that was mentioned by Ana Luisa and the idea of convention, which was crucial for the definition of conventionalism? And besides, would you define the very idea of a command as a text? I mean, interpreting it, should we interpret a command? Is a command something to be interpreted, like saying out? And finally, which is also something connected with this claim for more clarification, is law. Saying that law is interpretive is also saying that law is interpretive all the time. That meaning that all the practices that are connected to law are interpretive all the time.
Let me do Clarissa's question first. That was the easiest. Yes, that is correct. The more you make a constitution like a statute in terms of its representing the imprimatur of the majority that's currently existing in a society, the more it deserves the respect of the majority's right to rule, in which event the more reason you have to treat it as a text. So the more you make it easily amendable, the more you make it redone every 21 years, the more you make it like a statute, it has more like the authority of a statute. So that's the easy one. Formal life. In chapter 10 of this book, Wittgenstein's form of life joins Thomas Kuhn's paradigms as two exemplars of what I regard as a cognitive relativism, not necessarily of either Wittgenstein or Kuhn, but invited by those who use the phrases. So that it has become, as I call it, a kind of patter about relative to a form of life or relative to a paradigm with regard to anything that you ever used to say. I lived through both of those. Namely, you couldn't go to a talk about anything in the late 50s, early 60s without somebody doing form of life analysis on you. And in the 70s, it was always just your paradigm was the kind of response. I'm not a fan of either of those locutions. I do think that they are a kind of convention relative to which we are supposed to make judgments. And I'm just not a conventionalist about much of anything. Not about physics, and not about dream interpretation, and not about law and morality either. So it doesn't evoke much sympathy. It's the kind of thing that Gadamerarians do, which is to talk a lot from the outside about interpretive practices. And you want to say, yeah, that's all fine, the sociology. Go inside. Tell us what the criteria for validity are for your interpretations. Tell us what the criteria for syntactic individuation of texts are. Do something useful, in other words, rather than stand on the outside and blandly describe everything we're doing on the inside as following some practice or praxis. In a sense, you couldn't help but be true that there are generalizations that are true of what we're doing, and in that sense, there's a practice. But in the sense that we're bound by it, my metaphysical realism doesn't buy it. It may be epistemically, of course, we are situated knowers, always bound in the conditions in which we know. Yet what we aspire to is knowledge that corresponds to how things mind independently are not, how our conventions of the form of life or the paradigm in which we operate would dictate. That's not a sympathetic answer, but that's just me. That isn't my sympathetic mode. With regard to commands, well, the commander better have authority, or it's like when my kid gives me a command, I don't interpret it because I don't give it any authority. If I were a theist, I guess I would listen to God when she commanded something, but I don't have that one around either. Are there commands of people with legitimate practical authority? That's a tricky question. Raz has spent a lot of his life saying, well, there are lots of institutions that claim legitimate practical authority, so they can give you commands and thus a reason to treat their commands as a text which you must interpret to figure out what to do. Lots of people that claim that. The law claims it. But it only actually possesses it in those instances, rare enough, where the law has theoretical authority. Namely, the legislature or the lawgiver in general, you have reason to think, knows better than you what are your reasons for action. Then you have what Raz calls the normal justification thesis. You can justify those commands as being treated as a text, interpretations of which are to give you reasons for action or belief. Most commands, no. So Clarissa and I were talking on our way over here. She was stopping at the red light as we were crossing a street. And I said, don't you read T.S. Eliot, the English poet, who says you give up your sovereignty and you let a mechanical device dictate when you cross the street? She said something like, yeah, but it doesn't get you killed. But nonetheless, if there's nothing coming, what are you doing staring at that red light? Does that command have practical authority on your reasons for action? Or is it a theoretical authority, knowing better than you about whether there's a cop around or whether traffic is coming, not if it's very clear? So there's a command that I regularly ignore, and I regularly teach my students to ignore. It doesn't have the authority it pretends to have. So the answer to the commands is completely dependent on the answer of value. Is there a reason to treat a command as uttered from an authoritative source such that you have reason to use interpretations of it to guide your behavior? I think that was it.